Welcome back to Court TV Live. I'm Ashley Wilcott. So happy to be with you this Tuesday afternoon after a long weekend. We have a lot to cover today with our eye on 3 different trials here on Court TV. In California, the Jinx murder trial is set to resume tomorrow for closing arguments. The marathon trial of Robert Durst is coming to an end. Soon the jury will have the trial in their hands to determine whether Robert Durst is guilty or not guilty of the murder of his best friend, Susan Berman. And when one trial in California comes to a close, another one begins. Opening statements are set to begin tomorrow morning in the fallen tech CEO, Elizabeth Holmes. She will stand trial for fraud in a case in which prosecutors are challenged to show the intent of Holmes misleading investors. And today we're going to start our show in Ohio, where Stanley Ford is charged with killing 9 people in 2 separate house fires. If convicted, Ford could face the death penalty. Court TV crime and justice reporter Joy Lim Nakrin has more on the case.
A string of arsons still haunts this Akron, Ohio neighborhood.
It changed everything. Everything. And you don't know who to trust.
62-year-old Stanley Ford is accused of setting 3 fires on his own block, killing 9 of his neighbors.
9 people, 9 family members. I mean, the road's already so bad.
The first fire happened in 2016, killing 65-year-old Lindell Lewis and his partner, 66-year-old Gloria Jean Hart. This lot now sits vacant where their home once stood. Then came a car fire which injured no one, but in 2017, Ford allegedly set a fire which killed a family of 7. The victims, 35-year-old Dennis Huggins, 38-year-old Angela Boggs, and their 5 children, the youngest just 1 year old.
It was senseless. It wasn't no reason for it. You know, you took away children and parents.
Arson is so sudden and so tragic that I definitely feel for the families.
Prosecutors say Ford had disputes with his neighbors, which allegedly drove him to kill.
This man not went and killed somebody else. He burnt up somebody else's house already, and then went and did it to a family of 7.
When I moved here, I felt it was a nice community, and it's a shock that this has happened.
Ford is accused of more murders than any one individual in Summit County history, and he is facing the death penalty for his alleged crimes.
It's just not right. People like that should be put away, lock the key, forever.
I feel very badly for the families, and I hope that they get the justice that they deserve.
Ford maintains he is innocent and is being held without bond at the Summit County Jail pending the outcome of his trial. He tried to move the trial to another county, saying extensive media coverage had turned the community against him, making it impossible to find a jury of impartial people.
It's sad. And I would say, I hope justice does get served. So.
Early in the trial, the defendant's neighbor testified and described the victim, Lindell Lewis's house, as kind of wild. She then went on to testify about neighborly conversations she had with Ford and how he described himself as a protector of the neighborhood.
How are you familiar with that house, other than just being in the neighborhood?
And just being in the neighborhood, and it was always wild. It seemed like wild.
All right. And just so that we kind of have some baseline of what wild means to you, can you tell this jury a little bit about yourself and your lifestyle and your family's lifestyle?
We go to church. We take our family to church. We're very quiet in the neighborhood. We don't party or anything like that.
So you don't sit on the porch and drink?
No.
Play cards and smoke?
No.
All right. So, and so when you say that their house was wild, what types of things did you see going on at that house?
There would be people sitting on the porch for late night hours, like midnight or after. They would be drinking, smoking, loud music. there would be people that if we even drove up that way, that they would come out from that residence and either ask for money or for like some type of help.
All right. And not kind of the lifestyle you lead, is that fair?
That is correct.
Your husband, you mentioned that you've been married over 20 years. He, during that time period, 15, 16, and 17, where did he work? What geographical location?
He worked in West Virginia.
All right. So did he travel out of state a lot?
Yes.
And do you know whether Mr. Ford was ever aware of that?
I believe he did.
And why do you believe that?
He told me that he would watch over our house and keep an eye on it.
All right. And did he give you his cell phone number and your children's cell phone number?
He did.
All right. And that was in an effort, if you needed anything while your husband was away, that he would be there for them, for you and them.
Correct. That's correct.
You said you go to church. What faith are you?
Protestant?
Christian?
Yes.
Okay. And did he ever talk to you about what anything about his, I guess, belief as to his position in the neighborhood?
He recalled to us one time and told us that he felt like God had placed him in that area as he was like an angel of God to watch over the neighborhood.
And at that time, you felt that was comforting, correct?
Yes.
Now joining me to discuss all the legalities, criminal defense attorney Josh Schiffer. Josh, thank you so much for being on with me. And you know I want to talk all things evidence with you today.
Absolutely. Thanks so much for having me on as a guest, Judge Ashley.
Absolutely. All right, let's talk about this. So the prosecutor's trying to paint this picture of the very first house fire, and that's the one in 2016 of 719 Fulton Street, as a kind of a wild house. And in essence, I think, Josh, trying to paint the picture that the victim is responsible or somehow to blame. Is this something that's allowed under the rules of evidence?
It's all going to come up to a balancing test. It's so difficult for courts, and a lot of the confusion that it comes with what evidence is allowed or not allowed. It comes down to judgment calls made by a judge, whether certain kinds of evidence with guidance from the code and prior decisions, it's whether it's going to be more prejudicial than probative. The judge actually has an interest in not throwing too much bad evidence that is too explosive, that's too salacious at a jury, because the judge understands that jurors are normal citizens and they don't want to see a bunch of stuff that might shock or offend them, because that could result in their minds being changed in a way that's not necessarily fair to a defendant. So anytime character is going to come into a court, the judge is going to have to make very difficult decisions whether the jury's going to be able to see that character evidence. And then there's the character not just of the defendant, which there's rules about that, but there's character of the victims. A lot of our viewers are going to remember in the O.J. Simpson trial, a lot of the defense was go hang the victim. And there was a lot of discussion about the bad character of the victim, and it's still a very effective tactic. In this case, the prosecutor is obviously trying to paint a very specific picture regarding this house, how the community would view this house, and the people that frequented this house, in an effort to paint the defendant as a fully functioning member of the community that can then be put to death. Remember, that's their goal here. They need to not just win, they need to win and then some. That's the trophy on the wall for the prosecution. And in order to do that, they need a jury to find that Mr. Ford was a person in the community like pretty much anybody else.
And I know the defense is going to want to be able to say, hey, there were all these things going on. It was kind of a wild house. There were other people there, and therefore it wasn't our client. It was someone else. Josh, let's listen to a little bit, though. There was testimony from the sister of one of the victims of that first fire, Lindell Lewis, and she testified about somewhat of his character and whether or not he was a drinker. Let's listen.
Let me ask you this question. The people that were in the basement, living in the basement, the two gentlemen that lived in the basement, did they ever participate in the cookouts with you?
No.
Okay. Were you aware of any drug or alcohol issues for anyone who was living in that house with your brother?
No.
Okay. Were you aware of your brother's alcohol issue?
I've never seen my brother drink, so
Okay.
I didn't know of anything about no alcohol in
He
it.
never drank in front of you?
He's never.
Okay.
We could be around, we have Christmas parties, wherever we would have. Lindell never drank.
Okay.
All right, she'd never seen her brother drink, and then also testified there were no drug or alcohol issues in the house. And to me, I think that's really a point that the defense can use, Josh. What are your thoughts to say, listen, there aren't all these other people and doing all these illicit activities that could cause, contribute to, or be a motive for someone else to start a fire other than the defendant?
Well, it's always great as a defense attorney because we will take whatever fact is presented and then use that to accomplish our goal. And the goal in this case is to foment and farm reasonable doubt about how these fires may have started. It's not, I didn't do it. It's not that kind of case. It's not a case where they're going to really struggle over some of these facts as much as the struggle is going to be, could have something else happened, and manufacturing reasonable doubt by throwing up these different inconsistencies or possibilities or considerations that other people could have started this fire. This might not be the person who did it. And are you, juror, going to bet this man's life on how certain you are? And when you really get down to those thoughts, jurors are really contemplative. They take a lot of time when they are exercising any judgment, let alone the ultimate one. And having some just nagging questions in the background, that's what stops the state from pursuing the ultimate punishment.
All right, Josh, I like that expression, manufacturing reasonable doubt, and that a defense attorney wants to do that. Let's listen to some other testimony for you to tell me if you think that they've accomplished that, talking about or listening to testimony about drug addicts in the basement.
You knew the two people that lived in the basement at Lindell Lewis's house prior to you going to prison. You knew they were drug addicts, correct?
I didn't know them personally. I didn't know them personally. I never met them personally because that section of the house was blocked off. So I didn't know. I knew some people lived in the basement. I didn't know who lived in the basement.
You knew they were drug addicts in the basement, didn't you?
Yeah, I knew that.
How did you know that?
Because, I mean, I knew a couple of people, like you said, that used to go in and out of the basement. I knew people that used to go in and out of that basement.
So, how did you know the people that lived in that basement were drug addicts?
I didn't know that they lived in the basement. I know they used to frequent the house.
Well, you told us last time that they lived in the basement and they were drug addicts.
Well, I mean, listen, the one person that I identified don't live in the basement. I never met the gentleman that lived in the basement. The person that they used to come to the house to visit, the gentleman in the basement, she was a female and she used to come visit the gentleman in the basement.
How did you know that?
I mean, I was just sitting on the front porch talking to Linda a lot.
And you saw a lot of traffic going in and out?
I only saw one person go in and out of that basement.
You saw one person?
I saw one person. I saw a female person go in and out of that basement. And I knew her past, and I knew of her.
All right, Josh, is that an example of manufacturing reasonable doubt to have testimony that there are drug addicts going into the house or not?
It absolutely, it's a great vector for the defense to create a possibility of shenanigans. And I use that kind of dumbed down word because that's what the defense is throwing out there. It's not a specific counteracting argument that, no, Mr. Ford didn't start the fire, these people started the fire. It's the creation of a possibility that these other people who we really haven't heard from because obvious reasons, and that we don't know a lot about. They're the ones that actually started this fire, even though Mr. Ford may have been around, he might have had the opportunity, he might have even had a mental illness-based motive or something like that. These other people could have started a fire because of shenanigans. We don't know what's going on in that basement, but there are some druggy people down there. And you know, druggy people, they sometimes have fires or accidents or other people come over. It all sounds kind of ominous. And that's the real struggle with this death penalty ask. It's not just asking to send someone to prison. It's asking to put them to death. And that brings such a different level of analysis. Every little thing could upset the state's goal. And the state's working real hard on locking those down, and the defense is working really hard to take every little thing and expand it into something that the jury could say, hey, I don't know if that happened, but it could have. And if it could have happened, that's not beyond reasonable doubt.
All right, before we take a break, I have one more question for you because I want to talk a little bit about the pattern. The court determined that it would not separate these 3 charges into 3 cases against this defendant. We know that there was a house fire followed by a car fire, and the third allegation, 29 counts in all, is another house fire. And Josh, the reason, as I understand, that the court said, nope, these can all be tried together is to show the pattern. Do you think it is at all prejudicial, Josh, to have all 3 of these tried together against this one defendant?
I think in a weird way, it almost works better for the defense, or at least the defense can pick up the fact that this is the full weight and pressure of all the state systems ganging up and cumulatively burying this guy. If this was 3 separate trials, the other accusations quite possibly would come in. Prior bad actions, there's different issues if there were convictions or not, allegations. There's all kinds of back roads to bring in this subsequent bad behavior. So it's not like if 3 individual trials would have absolutely no knowledge of the other allegations made against Mr. Ford. But by combining them all into one mega case, it actually gives the defense an opportunity to say, whoa, look at how overly aggressive this state is. Look at how they're not treating this appropriately by going through them one at a time. This looks like a bum rush job by the state, and you can't put someone to death if the state's just going to gather up a bunch of stuff and dump it on you. Because cumulatively, the evidence, it's really strong.
All right, Josh, I so appreciate that opposite view as we continue to discuss a terrible case. 9 individuals were killed during these fires, 5 of which for children. And after the break, we are going to take a look at the testimony about those very fires. We'll be back here on Court TV Live. The trial of Stanley Ford will resume tomorrow when we expect to hear about the second house fire for which Ford faces a possible death sentence. Stanley Ford is charged with 29 counts, and he's accused of killing his neighbors in 2 different house fires. 5 of those neighbors were children, ages 1 to 14. The counts include aggravated murder, aggravated arson, and serious physical harm to a companion animal in the Huggins Boggs home. Ford is also charged with aggravated arson and aggravated murder in the Lewis home fire, with attempted aggravated murder of the surviving victim, Thomas Hughley. Before court dismissed for the day on Friday, the jury heard from the fire marshal and the forensic lab witness testifying about how the fire actually started in April of 2016.
Slide 6. What are we looking at here?
So this is the west side of the house. They're again showing some of the fire patterns from the front of the house extending up towards the roof level on the west side of the house, and just the general damage that the fire has left.
All right, now you see there's a yellow arrow that's been placed on that photograph. What's the significance of that arrow, or what is it?
So it's what we identify as fire patterns, and this is an upward outward, like a V pattern, what we call it. And you can see there's more fire damage down low, and then it's working its way upward and outward. And what it's doing here is going from the porch floor level, and then as the porch roof is consumed, it's working its way up to the other portion of the roof to the attic area of the structure.
And what does this information help you determine?
There again, it's telling us, it's identifying the origin area of the fire, and we can see by looking at these other windows, there's no fire, smoke, or heat venting out these other windows. So it's telling us, it's an indication that the fire is outside versus inside.
And of course, that DVR had been inside the house where the fire was, correct?
That's correct.
All right. So when you, did you then ultimately have a chance to view that?
Yes.
Prior to viewing that, did you then take all the information you had gathered from your investigation, and ultimately did you make an opinion as to whether this was an accidental or intentionally set fire?
Yes, I did.
All right. What was that opinion?
That it was an incendiary fire, that it was an intentionally set fire.
And where would the origin have been?
The origin would have been on the front porch of the house.
Which?
On the west side.
Okay. And that opinion that you're giving here today, is that within a reasonable degree of scientific certainty?
Yes.
And so, what were your conclusions on item number 1?
Item number 1 was positive for gasoline.
All right. And I guess to keep it clear, were any other items 1 through 10 also gasoline?
Yes, just item number 10. 1
All right,
and
so
10.
1 and 10 were gasoline.
Correct.
Were there any other positive results?
Exhibits number 2, 7, 8, and 9 were positive for a medium petroleum distillate.
All right. So what's the difference between a medium petroleum distillate and gasoline?
So when we think about the refinery process of crude oil and the distillation process that it all goes through, the gasoline is refined and distilled completely different than a medium petroleum distillate is. So from my point of view, on the chromatograms, they have completely different patterns and they have completely different peaks. So for those two, there's not really, like I said, gasoline has like almost 400 items, like components in it. It's completely different than a medium petroleum distillate. The pattern's completely different. It looks like a bell curve. Gasoline is like this long, lots of peaks, so it's completely different classification.
And so that the jury knows, I mean, I think gasoline is pretty self-explanatory, right?
Yes.
When you use the word gasoline, it's like we all use it, correct?
Yes.
And when you say medium petroleum distillate, what would be examples of a medium petroleum distillate?
A very common medium petroleum distillate is like the charcoal lighter fluids you would use to start your grills. There's also minerals, spirits, paint thinners, things that you would use to clean your brushes when you're painting. That's usually a medium petroleum distillate. Some wood stains are medium petroleum distillates, things like that.
Still with me, criminal defense attorney Josh Schiffer. Josh, I know we're talking all things evidence and perfect lead in to expert witnesses, because all of that testimony we just listened to were from expert testimonies, which means if properly qualified, they can give their expert opinions. First of all, let me stop there and say, how difficult is it as a trial attorney, regardless of which side you're on, to qualify an individual as an expert so they can give an opinion that won't be overturned on appeal?
The fundamental qualification process isn't that hard, because by the time you've actually gotten towards litigation, odds are your expert was selected a long time ago. They've had lots of opportunity to review the materials that you as the litigator presented to them. They've done reports. In lots of civil cases, you may have had depositions. Also, in certain states, such as Florida, you're allowed to do some expert witness testimony in advance of court. So it's pretty easy to qualify the expert as a basic threshold issue. Now, having a jury believe them, that level of qualification, having a jury trust them, that's an art as well as a science, because for one reason or another, juries can be very skeptical of paid compensated experts whose job it is to come to a conclusion specifically so that juries can believe them. Anybody with a little hiccup in the back of their brain of skepticism, they're always going to see an expert whose job it is to show up and tell people what happened. They may turn back and say, hey, why is this person saying this? Use those critical thinking skills as a juror, because oftentimes with experts, you're going to have a counter expert. And you get into what's literally called the battle of the experts. And it can get very expensive, very confusing, and muddy up the waters, which most of the time in criminal cases benefits the defendant.
So in this case, if these experts are to be believed by the jury, what it tells them is the what and the how. The fire was on the outside, set on the outside front porch, intentionally using an accelerant like gasoline. And so it doesn't tell you who did it. So as a defense attorney, what do you do with that evidence telling you what happened, how it happened, but not yet who did it?
You're going to explain to the jury how certain unmitigatable, unchangeable facts could occur, and then proceed to a result that does not inculpate your client. There could be, and I'm just spitballing right here, are there vandals in the area? There are arson vandal kids. Are there gangs? Are there homeless people? Are there drug addicts? Was this a fire that could have started with one of the other variety of fire ignition sources that generally gets taken away with the presence of an accelerant? But how many people do we all know that keep accelerants around their house? You go into my garage right now, there's a couple of dozen containers of accelerants. There's a container of accelerant in my kitchen cabinets. There's several. I know a lot of people that have a spare can of gas sitting out front to fill up the lawnmower. So the mere presence of an accelerant, that's going to say something, but there's still a lot of questions that get asked, and a good defense attorney takes uncontroverted expert testimony that an accelerant was present and uses that to leverage new questions that hopefully the jury's going to ask in a quest for unable to find reasonable doubt or manufacturing that reasonable doubt.
And we know that they still haven't even gotten to present evidence yet about the third fire, and that's the second house fire. So certainly we will continue to cover that trial here live on Court TV. Josh, you're going to stay with us. I want to shift our attention because the opening statements are set to begin tomorrow in California for the trial of fallen health tech CEO of Theranos, Elizabeth Holmes. When we return, we take a look at what we can expect in the trial with Court TV's own Matt Johnson.
How many of us live in a community where we think everything is okay, when many times it's really not?
911 was the emergency. There's a black male running down the street.
Ahmaud Arbery was jogging through a South Georgia neighborhood when he was followed by two pickup trucks with three men.
We pull up beside him, hey, stop, we want to talk to you. And he just keeps on running.
Bryant's truck is in the middle of the road. The McMichaels are behind him. He's trapped.
Should we have been chasing him? I don't know.
We continue to move forward in this prosecution.
Murder in the streets.
He was just jogging.
He was my baby. That was a heartbreaking moment in the courtroom.
There's a deep culture of racism here.
This is not some hate crime.
The Justice Department announced federal hate crime charges in the death of Ahmaud Arbery.
This makes you have to look at some tough issues.
Welcome back to Court TV Live. I'm Ashley Wilcott. So honored to be with you. Opening statements are expected tomorrow in the federal case against the fallen tech star Elizabeth Holmes. Holmes is facing a dozen felony charges alleging that she knowingly misled investors, patients, and doctors with falsified claims about her company's blood testing technology. Court TV crime and justice reporter Matt Johnson is here with us with what we need to know about the upcoming trial.
Boy, it's going to be another big one, Ashley, out there in California. We remember all of the covers. Elizabeth Holmes was on the cover of Forbes, Fortune magazine, holding that vial of blood with her turtleneck. Well, that's when the company went public. She was a huge star and the first quote-unquote self-made female billionaire. Now she's being called a devious mastermind behind a scheme to deceive wealthy investors. Tomorrow, after months of delays due to the pandemic, the trial against Elizabeth Holmes is set to begin. 2 years ago, Holmes and her ex-boyfriend, who was also Theranos COO at the time, Ramesh Sunny Balwani, were indicted by a grand jury on a dozen felonies. Prosecutors allege they defrauded investors out of hundreds of millions of dollars and knowingly misled hundreds of patients and doctors with false claims over blood testing. Holmes and Balwani are being tried separately. Both face up to 20 years behind bars in federal prison and more than $500,000 in fines if convicted, Ashley.
All right, Matt, I'm so glad you're here with us to bring us all the latest because this is a big trial. Let's start at the beginning. Tell us a little bit about what the jury makeup is following, I believe there were maybe 200 prospective jurors who were questioned.
That's right. You know, this trial is going to last 13 weeks long. It's going to go through mid-December. Here is a snapshot of that jury makeup that we have for you. Jury is made up of 12 jurors, 5 alternates, with 7 men and 5 women, and they're diverse in age and ethnicity. The jury pool started off with more than 200 people, and they asked them to fill out a 28-page questionnaire. Questions, they included things like, have they watched any of the media coverage? Hard not to in this case. Their feelings on law enforcement, if they had a history with domestic violence, and if they were vaccinated, because the judge dismissed several people who were not vaccinated, Ashley.
Let's go back to that, Matt, just a little bit. It's my understanding that it's one of the rules that you do need to be vaccinated to be there to serve. Is that accurate?
That is accurate in federal court there and that federal court system in California.
All right, opening arguments will begin tomorrow morning in San Jose, California. What do we expect, Matt, to hear during those opening arguments?
Okay, so the whole case rests on intent, right, Ashley? So prosecutors are going to paint a picture that Holmes knew that her technology, it didn't work. Technology that promised to run hundreds of medical tests using just a single drop of blood. They claim that she misled financial backers, misled consumers, customers, and patients. Prosecutors will also make claims that Holmes and Theranos executives destroyed blood test data before it could be reviewed by federal investigators. Now, as for the defense in all of this, they are going to argue that Holmes did nothing wrong in this case. Holmes is a victim of the Silicon Valley fake it till you make it culture. That's what they're going to say. She had no intent to defraud because she believed in the technology she continued to sell. The defense may also claim that she was in an abusive relationship with Ramesh Sunny Balwani, who was, again, her boyfriend at the time, and also the company's COO. Court documents claim that he controlled all aspects of her life and her decision-making. Documents state, get this, that he dominated her.
This is a case that I'm fascinated by because it has everything. Everything you just described. It contains, I mean, prominent individuals, a lot of money, billions of dollars. It has gained, therefore, national attention. So tell us a little bit about some of that media attention it's received. And I know that she's going to claim as part of the reason that she's not responsible or guilty.
Yeah, you know, early on, their defense was pointing to they were going to blame the media and how this whole thing came about anyway with the investigative journalism of the Wall Street Journal. But that also led to the book called Bad Blood. There's been 2 documentaries on it, one recently, 2 podcasts that you and I were talking about earlier before the show. There are 2 Hollywood movies in the works, and now 2 trials, one of which is playing out right now, including tomorrow with those opening statements, Ashley.
All right, I can't wait to hear more of your reporting, Matt, as we go forward. And again, federal court, so we know there are no cameras, there are no there are no recordings, but rather we're going to continue to report on it. It's going to be a big trial, so we will keep you posted here on Court TV. And when we return, Court TV legal correspondent Julia Janae will join us to discuss the trial of Robert Durst. That's next here on Court TV Live.
Is it a new question or am I answering the old question? I wish I could make facial expressions like you. Yes, that is my testimony.
Does it sound reasonable, Mr. Durst?
very, very, very credible to me.
Well, that was just a small peek at some of what we saw with Robert Durst on the stand testifying in his own defense in the Jinx murder trial. As you saw, Durst showed plenty of fight as he battled it out with prosecutor John Lewin during cross-examination, which lasted a total of 9 days. But Bob Durst did not just try to show dominance during his testimony. He also displayed some of that charm that no doubt helped him gain an acquittal in the Galveston trial for the alleged murder of Morris Black. Durst made sure to add a couple of jokes in response to Lewin's questions, and here are some of the highlights of Robert Durst's humor.
Next question.
You mentioned that you started running.
Why don't you let John tell you what questions he wants me to answer?
I'd rather not.
I'm available to talk. You're smiling again, and I just want to ask why you're grinning right now.
This is funny.
What's funny about it?
You're asking me the same question 15 times. What I'm charged with is killing Susan Berman. The fact that you're able to bring Kathy Durst into it and Morris Black into it just shows that the prosecution's lawyers have been doing better than the defense lawyers. I don't think they have anything to do with one another.
I don't know whether to object or say thank you.
If I,
Do not ask for a stipulation.
the fact that we've been sitting here all this time talking about stuff that never happened is funny. I think I need to congratulate you. You have just broken your personal record. You have filled up 18 lines on my tablet.
And I want to congratulate you. You set the perjury record. Does it strike you at all as strange that she chose a program at the very hospital that she wanted to work in as a doctor?
Maybe she wanted to minimize her commute.
I mean, that's funny, I guess. Is that a joke or are you serious?
Mr. Lewin, you may ask if he's joking, but the way you responded, it was commenting on his answer.
Okay.
Okay.
Are you joking or are you serious?
I'm joking.
Joining me now, Court TV legal correspondent Julia Janae. I've always called you All Things Durst because you have an amazing attention to the details in this case. Tell us, first of all, what we expect tomorrow at the beginning of closing arguments.
Tomorrow we expect the state to go first, and we've just learned not too long ago that there are going to be two prosecutors handling the closing statements for the state. They're going to start with Prosecutor Habib, and then that rebuttal at the very end, the last person this jury is going to hear from is Attorney John Lewin. In the middle, we'll hear from two defense attorneys as well. That's going to start with Defense Attorney Chesnoff and then Dick DeGuerin. But there's also many days that they think this is expected to go. They really think it's going to go into the 15th of next week as far as the days that there will be for closing arguments. And then we have the courtroom dark on this coming Friday and then a religious holiday, Yom Kippur, next week. So the jury is going to get a little bit of a bifurcated look at these closings, and then they're expected to go into those deliberations, which will continue on Friday if they have not come to a decision, not this Friday, but next Friday.
All right, Julia, let's talk about Judge Wyndham because he so far really hasn't set a lot of time limits, as we know by the amount of time it was taken to do direct examination and then even longer for cross-examination of Durst. Has he put any time limits on how long each side will have for their closing arguments?
It's interesting that you mentioned that about Durst being on the stand, his attorney taking 5 days, and then the state prosecutor taking 9 days to cross-examine, and he actually had to ask for more days at the end because the judge was getting a little upset about how long it was going, wanting him to wrap things up by the end of that week when he was under cross-examination on the stand. So we don't know exactly how long the judge will allow them to go, but we'll likely see some of those suggestions if things go long, the way it did when Durst was on the stand. But we do see that he is allotting, or court is allotting rather, those 3 days, and things are supposed to conclude by noon on September 14th.
There's a lot of evidence that's been presented in this case, a lot of testimony, and anyone who's watched with us knows that John Lewin is a prosecutor. Julia, he may rival you with knowledge of details because he knows this case inside and out. I'm just intrigued by the fact that we've now learned that he'll do the rebuttal, if I heard that correctly, and not all of the closing. Is there have they shared any reasoning behind their strategy or why each has chosen those parts, or do we know anything about that?
No reasoning that I know of. Of course, we'll be asking those questions and trying to get them as we get that information going into closing arguments tomorrow. But I can imagine that with the length that they want to be in front of this jury and the amount of information that they have to share, that he wants to be the last person that they hear, and he doesn't want them necessarily to be checked out of everything that he is sharing. I actually asked our field producer, Adrian Zulueta, who's been there in the courtroom since day one, how this jury is acting. Now, 15, 16 weeks into this trial, are they settled in? Are they just comfortable with how things are going? Or are they impatient? Are they looking at their watches and wondering when this is going to wrap up? She did say that they are looking more and more tired. They've had a lot of testimony that they've taken in. So I think it's going to be very important for these attorneys not to further draw this out for this jury. And it may be that rebuttal can be a lot more succinct, and that will fall on John Lewin, who we know is very invested in this case.
Well, great insight, Julia, and you're right. I think the jury is going to be exhausted no matter how attentive they've been. They do their jobs well, juries do, but it's been a very long time listening to evidence. Let's turn our attention briefly, if we could, to the jury instructions, because this is the opportunity that the judge did, and I took a lot of copious notes because every state can be a little different, but said, listen, jury, you're the one that decide the facts, and then you apply to the law to the facts, rather, as you find them. That's their job. That's what they're responsible for. But tell us, was there anything else unusual or to note regarding the jury instructions that they've already received?
Well, there is something that goes back to the promise that the prosecution has made to this jury, that they will show, or that the evidence is going to show, that Robert Durst committed not only the murder that they are in this trial for, the murder of his friend Susan Berman, but also 2 other murders, Morris Black, who he was already acquitted of killing, and the disappearance of his wife, Kathy, who was never found. So that was a promise that was made during opening statements that they would prove it. But John Lewin also said, I can't exactly say that we will prove it beyond a reasonable doubt. That is not the burden that is on the prosecution, but we will show you evidence that will show that this is in fact the case. But in the jury instructions, they are charged with understanding that the uncharged acts, so Morris Black and Kathy Durst, those deaths or murders, the jury only has to believe that they were proven by a preponderance of the evidence. That's the burden of proof for those other 2 murders, which just means really 51%, 50.1, just a little bit more than not. So that's a very different standard for those 2 alleged crimes compared to the death of Susan Berman, who they, of course, have to prove beyond a reasonable doubt.
And I think that's a win for the prosecution because you're right, it's a lower standard, a lower burden. And again, he's not on trial to figure out whether or not he committed those crimes in a guilty verdict, but that is instead only as to Susan Berman that they must make that decision. The other thing, Julia, that I found very interesting was some of the jury instruction regarding deceit. And here's how it was worded. If a witness lied, and a juror believes that it was about something significant, then they were instructed, you don't have to believe anything that witness said. But the rest of that instruction was, or you can choose to accept part of what they said as true and ignore the rest of what they said. And I think this case, that's the crux of the matter. Are they going to believe Robert Durst and give him the benefit of the doubt, or are they going to say, nope, don't find him credible, don't believe him, he did this?
Well, it's really important because we know on the stand, Robert Durst admitted to lying in the past, telling statements that were not true over and over again. He said that it was a minor perjury when he told the jury back in Galveston, Texas, that he was in Northern California and not in Southern California, where Susan Berman was. And many of his lies surround his connection to Susan Berman's death, that he was the one who wrote the cadaver note. So this jury, that's an important jury instruction because they'll have to make the decision on whether or not they believe all of what he had to say on the stand, whether they believe none of it, and whether they just look at the rest of the facts in the case.
Excellent. Thank you, Julia Janae, for being with us. When we return, we're going to break down the 3 crimes that prosecutors are trying to prove that Robert Durst committed. That's next here on Court TV, your front row seat to justice. Welcome back to Court TV Live. I'm Ashley Wilcott. Thank you so much for joining us this afternoon, where I want to start this hour heading over to California for the trial of Robert Durst. Court is dark today, but closing arguments are expected to start tomorrow at 12 p.m. Eastern Time. As soon as closing arguments begin in that California courtroom, we will take you there live so that you will not miss any of it. But in the meantime, I want to take this opportunity to delve into the 3 deaths surrounding Robert Durst. 3 deaths that prosecutor John Lewin said he would prove in his opening statement.
The evidence in this case is going to show that he is responsible for the disappearance and the death of his missing wife, Kathy McCormick Durst. We're going to show that Robert Durst murdered his close friend and confidant, Susan Berman. And we're going to show that he did that with the motive and because she was a witness. And by witness, meaning that she assisted him in covering up the killing of his wife almost 20 years earlier. Finally, we're going to show that Robert Durst killed, dismembered, and dumped Morris Black's corpse, his body parts, in trash bags into Galveston Bay in September of 2001. So there's going to be 3 killings that we are going to prove.
Throughout the trial, Durst was asked many times if he killed Susan Berman, his wife, or Kathy. To no one's surprise, he denied it each time. But note that he also testified that he would not ever admit to it, even if he did kill them.
So you are admitting that to the best of your knowledge and memory, you have committed at least 5 instances of perjury while testifying at this trial, correct?
Correct.
And you have also said from the first day of your cross-examination that if you had killed Susan, you would lie about it, correct?
Correct.
You have said that if you had killed Kathy, you would lie about it, correct?
Correct.
You have said that if you had murdered Morris, you would lie about it, correct?
Correct.
In order to break down each of these deaths, I want to bring in my own expert. Joining us now, forensic criminologist Dr. Laura Pettler. Dr. Pettler, thank you for being with us today. I have to just throw out a general question. We're going to go through each of the 3, but before I do that, what are your thoughts as a forensic criminologist when you hear that he's been involved with the disappearance of a wife and the death of a best friend, as well as a neighbor being killed, and he admittedly dismembered that neighbor?
Hi, Ashley. Thank you for having me today. You know, the first thought that comes to mind when someone like this is involved in multiple incidents of either missing people, dead people, or somehow injured people is that he has some type of a personality disorder right off the bat. And that kind of personality is toxic to other people. However, they end up gravitating toward him, attaching to him, and then they end up in physical, sometimes mental, sometimes financial trouble because of their linkage to him. So my very first thought right off the bat is this is a guy that just has the ability to attract people to him, but once they get in with him, the relationships are very toxic.
And I know that you specialized in a number of different things, but some of your specialties include staged accidents, missing persons, homicides. So let's delve into Kathy Durst. As you know, almost 40 years ago, she disappeared. There's been no evidence that she is actually dead, but she disappeared. So how would you deal with that fact in terms of forensics, and you don't even have a body or a crime scene?
So the problem, of course, comes in when you do have the accusation against somebody that they are involved in the missing person case, or what is assumed to be a homicide in this case. How do you prove something like this? Well, there's a tremendous there's a way that we can do this through circumstantial evidence, but it takes a very systematic, multidisciplinary, victim-centered approach in order to accomplish those goals. There's no way to do it based in just the physical evidence because, as you mentioned, there isn't any physical evidence. So when there isn't any physical evidence, we have to take it a step further. We start with the victimology. We study who Kathy was, what she was doing, where she was in her life. We know that she was in medical school just a few months from graduation. It's very unlikely that she's going to want to go missing on her own. Then we look at her intimate partner relationships. We look at the relationship she had with her husband at the time. We know that there were reports of Kathy having been treated for some type of bruising or some type of an injury within the last 3 weeks of her life. Most often in domestic violence incidents, and specifically in domestic violence homicides, where we see staging most often is the fact that the incident that basically is the catalyst for the murder occurs within maybe 30 days prior to the death of the victim.
So let me ask you this. I'd like to listen to a little bit of what Durst had to say in his testimony about if he would have told you that Kathy was dead and he had killed her. Let's listen.
As you sit here today, do you believe that your wife is dead?
Yeah.
As you sit here today, do you believe that your wife died at or very near the time that she disappeared?
I have no idea.
And you've also testified that you are unaware of any crime scene, correct? You've said, I don't know where there's a crime scene with Kathy.
I agree.
You testified that you did not kill her at the South Salem house, correct?
Correct.
You've testified that you did not dismember her at the South Salem house, correct?
Correct.
You've testified that the blue light that your neighbor Ruth Mayer saw, that does not exist, correct?
The blue light was her imagination.
And Mr. Durst, you have also testified that you have no idea if Kathy did die, what happened to her, correct?
Correct.
You don't know if she drowned somewhere, correct?
Correct.
And in fact, when you have been pressed regarding explaining where she is, you have said you have no idea. Is that correct?
The only idea I ever had was related to cocaine. She was buying lots of cocaine, and people who sell cocaine tend to be difficult people.
Right, and Mr. Durst, you have also said, with respect to Kathy's death, you've also said that if you had killed her, you would lie about it. You wouldn't tell us, correct?
I would not tell you, correct.
All right, Dr. Pettler, knowing that she's a missing person and using the technique that you've just described, which means you can't just base it on physical evidence, how does his admission that, yes, he thinks she's dead and she wouldn't tell you if he had killed her, rather, how does that play into your analysis?
So one of the things that I would immediately go to is something that we call our conflict resolution benefit matrix. Murder is most often conflict resolution for the offender. And in this case, there was some particular conflict between him and her if he indeed did kill her. And he resolved that conflict with murder. When the conflict is identified, so you ask who's in conflict with the victim, and then you ask what is the conflict between the victim and the offender. Could it be money? Could it be sex? Could it be the relationship? Could it be the priorities? Could it be school? There are so many different things that it could be in this particular case. Once you identify the conflict, a lot of times the crime scene or the way that the person is either missing, injured, or killed is a reflection of not only the personality of the offender, but it's also a reflection of the interaction, this vivid interaction or divergent dualism between the victim and the assailant. In this case, Robert Durst is the type of person who is going to have complete power and control over his victims. He is going to maintain that control at whatever cost. And after that, we go back to the crime scene from the standpoint of there is no evidence in this case. That means that he was in complete control of it. If he was indeed the person that did kill her, he made sure that it was very organized and it was very discreet so that he could get away with it. And then after the fact, after she goes missing, is the conflict resolved between Kathy and Robert Durst? I don't know. If he's the one who killed her, he said he's never going to tell. It's very typical of people like this to take it to the grave because it's the only things they have. It's the only thing that they can hold on to. It's the only thing they can revisit to relive that murder over and over again in their minds.
All right, let's fast forward now to 2001, and this is when Morris Black, a Galveston neighbor, was killed, and Durst admitted that he dismembered. The other thing that he did testify to is that the shot was accidental, and in the interest of time, I want to move us to the next piece of what happened in court. And Laura Pettler, it's a little unbelievable, but the two defense attorneys actually demonstrated, based on what Durst was saying happened, in the courtroom, and we can watch here. So I'd like you to watch this with us. Walk us through if you have any immediate thoughts as they're demonstrating.
Okay.
And Durst would be the one in the light jacket behind the victim, Morris Black, laying on the ground.
Okay.
And there's no talking. This is what we see. He has the gun.
I see. Okay.
He said he came up from behind him to disarm him and accidentally discharged the gun. This is what you have. This is what the jury has watched as to what happened. So again, Durst is behind the one in the dark gray, and they demonstrate that he went to get the gun and he ended up discharging the gun and it shot Morris Black. Is this plausible? I know this is hard. First of all, just give us your thoughts that this is what the jury sees.
Right. The jury is seeing this, and I assume that they're talking while they're demonstrating this, but he's grabbing the hand and he's putting his hand over Morris Black's hand. And then the next shot is of both attorneys lying on the ground, Ashley, and and Robert Durst has the firearm pointed at Morris Black in the demonstration. So could this happen? Yes, but this is, why are you going to grab him from behind? Why are you not going to just go straight to him? And why is he trying to disarm an armed man like this from behind? It doesn't make any sense. This is an extremely illogical recreation. And it's important to remember that crime scene reconstruction, is a glimpse of the actual events. It can never tell us the entire thing. So to buy this entire scenario right here is to be, completely in error. Secondly, recreation, which is kind of what they're doing halfway here, and then they're also reenacting. There is only theatrical components to this. There is no scientific merit to this. The only type of reconstruction per se that we have with scientific merit is crime scene reconstruction, where measurements and all these kinds of things are used. This display here in the courtroom, this is consistent with what we call reenactment. And again, it's got no scientific merit.
All right, I'd like to add to this some of the description that Durst gave on the stand, Laura, of dismembering or chopping up the body of Morris Black. Let's listen.
All right. So now we're at the point where you put the drop cloth over Morris Black and you went to the liquor store, Economy Liquors, and you bought a bottle of Jack Daniels. What did you do next?
I walked back to the apartment, got the axe out of Morris Black's apartment, and I proceeded to chop the limbs off of Morris Black's body.
So what did you do about disposing of the body parts?
I put the body parts in garbage bags and put the garbage bags in my Honda CRV.
There were many things that would lead directly back to either you or Morris Black in the bags. Did you think about that when you were loading those bags up, if you know?
No.
And what did you do with the bags?
I went to a part of Galveston Island where there's a pier, and I carried the bags to the end of the pier and threw them into the Houston Ship Channel.
Did you know the depth of the bay at that point?
No.
Could you see the bottom?
No.
Do you know how many bags there were?
No.
Did you throw all of Morris Black's body parts in the bay?
Yes.
All right, we have to do this one quickly because I do want to get to the main case, which is Susan Berman. But did you have any concerns about the manner in which he just described dismembering Morris Black?
Yes, and pursuant to dismembering Morris Black, the only reason somebody stages a murder or dismembers a body or any of those kinds of things related to this type of homicide is because it's like a freebie. It's saying, hey, I knew the victim, I had a relationship with the victim, and this is how I am separating myself and creating distance between me and the victim. One of the things I think it's very important to point out about Robert Durst here is what he's describing is something that we here at LPA call cognitive overload, meaning that the crime scene stager gets so overwhelmed with all the details of how to stage such a murder that they miss obvious things. Like obviously, like the attorney said there, he is going to be connected to Morris Black in so many ways. Did that ever cross your mind, Mr. Durst? No. He said no. And then taking all of the bags, dumping them into one part of the bay over the pier, that again, we don't see that all the time with people that dismember bodies. A lot of times they put them in various places, and people don't move bodies they don't have to. And if an offender kills a victim in the victim's environment, they most often leave the body live. But in this case, he wanted to get rid of the body because the body was evidence of what actually happened.
All right, let's move forward to Susan, because Susan Berman and his best friend, this is the one he's on trial for murdering. I'd like to first listen to the description of how she was killed.
Describe what this showed, this external examination.
Well, as you can imagine, we're looking for reasons for somebody having died. In this particular case, like I stated previously, there's a gunshot wound to the back of her head. We're looking for any other signs of injury. There is another injury to the hand, which I'm sure we'll get to.
Okay. Aside from the injuries, upon an external examination, aside from that, was there an internal examination done?
Yes.
All right. Based on your external and internal examination, not when I say you, done the work you observed in the file, did this appear to be, was there any health concerns that you observed for this particular woman?
No, not at all.
Okay. Did she appear to be consistent with a healthy 55-year-old woman?
Yes.
Was there an examination done of her major body systems and organs, such as cardiovascular, respiratory, gastrointestinal, et cetera?
Yes.
Et cetera?
Yes.
Any issues?
No.
So let's talk about the signs of trauma that were observed. What signs of trauma were there to this person's body?
So again, we talked about the gunshot wound to the back of her head. She has a contusion or a bruise to the back of her right hand. It's about 1/2 inch. And aside from that, no other trauma.
All right. So if we could please describe this gunshot wound to the back of her head for the jury.
So as you can see, it's right almost directly in the back of the head. It's 3.5 inches from the top of the head down, 1/2 inch to the right, And the injury itself, as you can see, it's stellate, it's star-shaped, measures about 2 inches in dimension. It's because of what's called gas effect of the weapon. We'll get to that. But this is all the characteristics of an entrance gunshot wound.
So how can you tell this is an entrance wound and not an exit wound?
Because there's only one hole. That really helps me. There's only the one hole. There's a bullet in the head. Therefore, this has to be the entrance.
What can you tell forensically from that description by the medical examiner?
So the offender in this case, wanted to come and attack this person from behind. And sometimes we see that in anger retaliatory offenders, but oftentimes we see that in just the power assertive offender who needs to remove this victim from existence. It's not a huge angry based attack where there's lots of stab wounds and lots of injuries and layers of injury to the victim. Well, what it says instead is, you know what, you either are in my way or, you just need to get out of the way or get out of my life, or something you shouldn't know, too much. And in this case, I think that's what this was about, is that she knew so much about him being his best friend that he just needed to silence her. And in staged homicides, keeping a secret is often a recipe for murder. Rejection, abandonment, any of these things, regardless of the fact that they had just exchanged money recently, it doesn't mean anything. The forensics says, get out of my way. The evidence of injury, it's a purposeful location on her body. Her gunshot wound is not to her big toe. Her gunshot wound is to the back of her head, just a little bit past midline. It says, I just need you out of my life and I need you gone. You're a problem in my life. You're a problem in my situation.
All right, Dr. Laura Pettler, you're going to stay with us. And after the break, our legal analysts are going to join us to help us look at these 3 crimes and legal arguments to be made. That's next here on Court TV Live. Still with me, forensic criminologist Dr. Laura Pettler, and I want to bring back in criminal defense attorney Josh Schiffer, and also welcoming this hour trial attorney, former prosecutor Walter Gabriel. All right, let's jump right into it, because Laura Pettler, you really, I think, put a pretty convincing case out there that forensically there's an opportunity that, yes, this death, this of Susan Berman killing, was caused by Robert Durst. So let me go to you first, if I could. Walter, share with me, as a defense attorney, how do you push back on the forensic description of the gunshot wound to the back of the head that was done maybe not as an attacker, but a power attack to get rid of this person, which fits the motive put forward by the state that he didn't want her telling anybody anything?
Well, Robert Durst has a way of explaining away a lot of things, as he's done in this previous trial. So as defense counsel, you rely on, obviously, what your client tells you and how things went down from his account, as he did in such detail with the previous trial. Now, what's difficult to go against is a gunshot to the back of the head. You'd have to get pretty creative to get around that one. It's to say that you weren't the instigator, you'd have to come through with some sort of scenario as to how you somehow winded up behind a person who was a victim and explain how you were actually acting in self-defense. Aside from the obvious, which is saying that you didn't do it. You'd have to somehow say that you were acting in self-defense if you would concede that it was you, in fact.
All right, and with Susan Berman, Laura, if I could ask you next, please. We know that there's no evidence that's been presented of the gun being found, or any fingerprints at the scene, or any other evidence to directly say, here's a videotape and Robert Durst came in the house and shot her in the back of the head. We don't have that kind of evidence. How often forensically do you see these crimes being solved by the circumstantial evidence that you mentioned earlier?
Many and many times. When I was in the DA's office, the prosecutor I worked for, we tried circumstantial case after circumstantial case that had no physical evidence except a purposeful location type of a wound, like the case of Susan Berman. She has a wound to the back of the head, and it's not possible. Of course, it is possible to shoot yourself in the back of the head. Nobody's arguing that. It is the type of location that forensically says to us, get out of my way. And it's an organized location. It's an organized crime scene. It's an organized wound to keep it clean, keep it very clean, keep it tidy, keep it discreet. And nobody ever saw anything, including her. They like that kind of an ambush. We prosecute those types of cases as a DA's investigator from the standpoint of collecting circumstantial evidence and using it to bolster and illustrate the nature of the case in chief.
All right, Josh, all things evidence. How do you argue a case supporting Durst's version versus some of the forensic analysis we've been through on all three of these deaths? What's your best case from your perspective?
Well, remember, Durst isn't carrying the burden here on all this. This is a state story, and a prosecutor's going out there to tell the state line, and look, they've got some forensics, and this is the only way it could have happened. And every time an expert gets up there and says, this is the only way it could have happened, disagreeing with that expert now suddenly castigates you as a decision maker. And by disagreeing with any part of it, you now built reasonable doubt. And it's when plaintiffs or defendants go too hard, they double down on this is exactly what happened. When you've said that, you create an opportunity for something else to actually exist. It's why Dick DeGuerin did such a masterful job putting this case into action. Jurors, when they hear testimony, use a little part of their brain. When they see pictures, they use a little part of their brain. If they see the combination of action and words and smells and vision, turning on all of the parts of their brain, looking at that wrestling on the floor, that's an immutable moment in this trial. And if the defense proved the point that, hey, we understand the state has their position, but this could have also happened as well, that eviscerates the state's ability to say we're right on everything else.
All right, Laura, let me come back to you because there's this feeling, I think, if you've watched all of this trial, which we've done here on Court TV and followed the testimony being presented, it feels like there's this argument of it can't be coincidence. 3 people in his life have ended up either 1 missing or 2 dead. Can't be coincidence, therefore he killed Susan Berman. Is that something that you think is a possible scenario? I mean, it is not a possible scenario in this case. Do you think that there's the opportunity to say it's not just coincidence, it's all of the science behind it?
I think that there is quite a bit of science behind this. And I think that when we take a case like this and we put it through a systematic, scientific, multidisciplinary, victim-centered approach, which is required for something of this nature, you come out with one person benefiting from every single death in this case, from Mr. Black's death, from Susan Berman's death, and from Kathy's missing person assumed homicide case. And the only person that benefits from all 3 deaths is Robert Durst.
So, Walter, jury. We know the importance of the jury. I believe in our jury system. But when you have a witness like a Durst that, quite frankly, no attorney can control because he has a lot to say, the jury gets to absorb all of that and hear all of that. So in this trial, would you, as the defense attorney, have any concerns about what the jury may take away from listening for this many months?
I'd have several. One of the, well, a couple of the concerns are, do you think that your client is likable and relatable to the jury? And I think the prosecution has done a great job of taking those things away from the defense in this case. The cross-examination has included welfare fraud that Robert Durst has committed in benefiting from food stamps while he's part of the ultra elite in society. Robert Durst has also admitted to perjuring himself several times on the stand. And if a jury finds a person unlikable and unrelatable, they'll hold those kind of statements against the defendant, and it'll come out and it'll be a very damaging outcome, I believe.
All right, Josh, what are your last words about the evidence in this case and also the appearance of Durst, his health, how he dressed and put a jacket on for his last few days of cross-examination? What do you think that offers to a jury or not?
This is a giant show and a game for Robert Durst. He's towards the end of his life. He's going out with a giant flash. And I believe he's done a very successful job creating reasons why a jury might acquit him. If I'm the state in this, I'm going to try it just on something that the good doctor just added, which is that there's so many coincidences with this. How many coincidences before that's intent? And I wouldn't get bogged down in all the nitty gritty. I would just go with the totality. I think right now, the way the state's going, I think Mr. Durst has a strong shot.
All right, we're certainly going to continue to bring you live coverage. The opening statements, again, are expected to begin at 12 noon Eastern time tomorrow. Dr. Laura Pettler, thank you so much for joining us for All Things Durst. I know that Josh and Walter, you're going to stay with us. We're going to continue our coverage of the Jinx murder trial and take a look at the cross-examination of Durst up next here on Court TV Live.
As you sit here right now, given that you've now admitted to having already perjured yourself at least 5 times in this trial, and having said that you would perjure yourself regarding whether you killed Susan, whether you killed Kathy, whether you murdered Morris, can you explain how anybody is supposed to figure out when you're telling the truth and when you're lying?
They are supposed to use their life experiences to come to a conclusion about whether or not I killed Susan Berman.
Robert Durst was on the stand for 15 days, with 9 of those days being intense cross-examination by a very high-energy District Attorney John Lewin. I want to take this time to look back on some of the biggest moments that happened with Lewin while he cross-examined the defendant on the stand.
As you sit here, would you say, are you nervous? Is it a sense of anticipation? How do you feel?
I feel relieved that I'm finally getting close to getting this over, and I feel nervous, of course.
How would you describe your memory overall?
Well, you do on a scale of 1 to 100, and if 100 is perfect and 1 is terrible, I would think I'm a 60 or a 70.
The loss of your mom when you were 7 years old, that's a tragedy almost beyond description, and it's understandable that it had a lifelong effect on you, but would you agree that your siblings lost their mother too, and none of them is in any way similar to how you are? You're not blaming your adult conduct, the things you've done, on the loss of your mother, are you?
No.
On direct examination, do you remember the first thing that Mr. DeGuerin asked you?
He asked me if I killed Susan Berman.
If, in fact, you had killed her, would you tell us?
No, I did not kill Susan Berman. But if I had, I would lie about it.
Did you tell the whole truth and nothing but the truth during your trial testimony in Galveston?
I lied in the trial in Galveston. I said I was in Northern California when Susan Berman was murdered, and that was a lie.
Is that the only lie you told during that trial?
The only one I'm aware of.
You know you wrote the cadaver note, correct?
I knew I wrote the cadaver note, correct.
And I just want to make sure you weren't having some kind of, let's see, Jack Daniels or Percocet or marijuana or crystal meth high when you made that statement, correct? You knew.
Which time I made the statement? I made the statement repeatedly.
No, I'm asking you, Mr. Durst, that in essence, that's a statement when you made it. You knew when you were, as you were making the statement, you know what, I'm saying whoever wrote the cadaver note has to be the killer. And I know, I'm not forgetting, I'm not delusional, I know I wrote the cadaver note, right?
Correct.
Until that point in your life, until age 71, you basically felt, I don't have to follow the rules. How would this relate to a plea bargain? I'm trying to understand that.
There's nothing illegal about saying I don't have to follow the rules. Whatever I was doing in that court, that room with you had to do with my doing a plea bargain. I thought it was what you wanted to hear.
You were trying to make a plea bargain where you offer to say what happened to Kathy and what happened to Susan, but in the end, you didn't know what happened to Kathy or Susan, so how are you ever going to be able to make a plea bargain, Mr. Durst? You have just basically testified, correct, that the only reason Kathy got into medical school was because of your father, Seymour Durst, correct?
Correct.
And you've said that she didn't get into any other medical school that she applied to, correct?
Correct.
Mr. Durst, isn't it true that the reason that you diminish Kathy's accomplishments is because her success was very difficult for you to handle?
Just the opposite. I was enormously proud of Kathy.
Your memory about the innocuous detail of what day you moved into the apartment, would you agree it is substantially better than it is about an incident where you violently threw a large glass of water at your wife in the car? Is that true?
It's rather substantially different incidents. I have no idea when the large glass of water thing theoretically happened.
The Christmas incident, the throwing the bottle of soda at her, the statement that your life had basically become a bunch of fights, pushing, shoving arguments, your statements in front of her mother about your penis, that none of that constitutes, in your opinion, physical or emotional abuse?
Correct.
What have I said before? What does Lewin know? What lies have I told that he knows about? What can I say that he can't impeach me on? And then you come up with an answer. That's what you're doing, correct?
No.
Overruled. I noticed you smiled right when you answered. Why are you grinning?
Why am I smiling?
Yeah, you smiled when you got a big smile on your face, correct? And then you said no. Is that what you did?
I'm not looking in the mirror. If I'm smiling, I'm smiling.
Does it seem strange to you that you would remember all the other details which you listed off, but you don't remember that detail? Does that seem strange?
No, it does not seem strange to me.
You're smiling again, and I just want to ask why you're grinning right now.
This is funny.
What's funny about it?
Asking me the same question 15 times.
You were able to answer the hypotheticals about Morris, Kathy, and Susan because it was true. You knew, since you had murdered all three of them, that you would not admit to doing it. Is that correct?
But I was advised that I should not answer hypotheticals that are not true. And it was not true that I had killed anybody.
And after the break, we are going to take a look at the defense's case. Stay right here on Court TV, your front row seat to justice. Before we went to break, we saw what happened during cross-examination of Robert Durst. But that was only part of his testimony. I want to now look at some of Bob's testimony when the defense attorney, Dick DeGuerin, was the one asking the questions on direct examination.
Do you want to testify in your own behalf?
Yes. Stewart called me up and said the two cute girls had just moved into the building where he was renting an apartment. One of them was Kathy McCormick.
Did you think that Kathy had voluntarily gone off someplace rather than she was missing?
Yes, I figured either her sister Mary Hughes or her friend Gilberta Najami was helping Kathy hide out somewhere.
When you talked to Susan, what did you tell her?
I told her I hadn't seen Kathy since Sunday night, and then I had gone to the police on Friday night.
March 3rd, 99, $25,000 to Susan Berman. You say you think it was for a car?
It might have been for her car. Her car had been falling apart.
The ultimate question is, was Susan trying to blackmail you for anything?
Never. I walked into the house, hollered Susan a few times, and figured either she's still on her walk or she's in one of the bedrooms. And as soon as I got in front of the first bedroom, I did a double take. When I saw Susan lying on the floor with her feet on her back, with her feet towards the front of the house.
Did you write that letter?
Yes, I did. I mean, I have difficulty believing in myself that I would write the letter and have not killed Susan Berman.
Was Susan blackmailing you?
No.
Did Susan ever threaten to blackmail you?
No.
Let the jury know a little bit about the relationship that you had with Morris Black.
The little touristy stores would stay open at night, and we would go to the art nights. Several times, we went to the movie theater on Galveston Island.
Did Morris have problems with people in Galveston?
He would get into arguments with everybody.
Sustained.
I decided to dismember Morris Black's body
Why?
so I could carry the pieces out of the apartment.
Mr. Durst is allowed to express his state of mind about this man, which is that he was afraid of him, but not afraid of him because he would be a witness, afraid of him because he was violent, he posed a threat, and he responded accordingly and lawfully when Mr. Black pointed a gun at him.
Jury, ladies and gentlemen, you have heard of this violent conduct. You may consider it to determine whether or not Mr. Durst acted violently, that he indeed was the aggressor in Galveston.
Were you using any drugs during those interviews?
Yes.
What were you using?
Whatever was crystal meth.
Later in the recording of your talking to yourself, you also said, kill them all, of course.
Or perhaps I said very softly, as they'll all think I killed them all, of course.
Would you have pled guilty to practically anything to get out of there?
I would have pled guilty to killing Susan Berman, to killing Kathy Durst, to killing Martin Luther King, to killing John Lennon, to killing Jack Kennedy.
Did you think that you would have to give details in order to plead guilty, or even no contest?
I did everything I could to get them interested in making a deal with me.
Did you kill Susan Berman?
No.
Do you know who did?
No, I do not.
Still with me, criminal defense attorney Josh Schiffer and former prosecutor trial attorney Walter Gabriel. Walter, let me start with you if I could. Can a closing argument be powerful enough by a defense attorney to convince at least one juror to acquit Robert Durst?
Well, I'm convinced that he's going to be found guilty, but it's of course possible. And he was acquitted of the allegation of murdering Morris Black. So I think there's a chance, and I just like I think there's a chance in nearly any criminal trial. I think it's unlikely here, but I will leave that possibility open.
So it's fair to say the closing argument is a powerful piece of opportunity to convince at least one juror, Walter. Is that fair?
Absolutely. And in a case like this, where you have all this evidence and you have weeks and weeks of trial testimony, I think we're well beyond 50 days. Closing arguments are going to be very important because they're going to help summarize what happened in these 50+ days and help refresh the jurors' minds on not only what was interesting and stayed in their minds, but what's legally significant to each side. So I think it's especially important here.
All right, Josh, in the last 30 seconds, I know that's a lot to ask because there's so much, but in your opinion, did the state deliver what was promised in their opening statement?
I don't think so. The opening is the story of the case and the closing is the story of the trial. Dick DeGuerin has set this up to be a trial within a trial, the case within a case. And I put me down as someone who thinks Mr. Durst dies in his own bed.
All right. Thank you, gentlemen, both of you, for being with us as we continue to cover Durst. Again, closing statements are scheduled to begin at 12 p.m. Eastern Time tomorrow. We are going to break down all 3 trials we are covering at Court TV when we return. Don't go anywhere. You're watching Court TV, your front row seat to justice. Welcome back to Court TV. I'm Ashley Wilcott. So honored to be with you this Tuesday afternoon. Court is dark in Ohio today, but we are expecting testimony to resume tomorrow. The prosecution is expected to transition its case from the house fire that first occurred in April of 2016 and focus more on the fire that was the second fire in May of 2017. Stanley Ford is accused of killing 9 people in 2 separate house fires. Throughout testimony, it has come out that Ford described himself as an angel of God and a protector of the neighborhood. The prosecution presented testimony over the past 5 days, trying to present a motive of why they think Ford started the fire, killing Lindell Lewis and the second victim, Gloria Jean Hart.
Now, Miss Gary, did you know the defendant in this case, Stanley Ford?
No, I can't say I really knew him.
Okay.
I just know him from watching him cut his grass and waving in the morning.
Would you see him outside when you would walk to the store?
Yeah, sometimes.
Would you ever have conversations with the defendant in this case, Stanley Ford?
No, not really.
Okay. You would just wave to him as you walked by?
Yeah, or I drove by.
Can you tell the jury if you knew, and if you don't, that's okay, of any issues that the defendant, Stanley Ford, was having with Lindell Lewis?
Yeah, they had disagreements all the time.
And how do you know that?
Again, walking the neighborhood.
And what would you see?
The last time I can truly recall was an argument between Mr. Ford and Mr. Lindell about the traffic that was going over at Lindell's house.
Okay.
And all the beer cans and stuff that just basically ruckus over at Lindell's house.
Do you recall Lindell saying anything to this man during the time period that you were at his house putting up the cameras?
I mean, I remember some light grumbling going on between the two.
When was this happening?
Me and Chandler was installing the back cameras. When we was installing the back camera, we kind of really heard something. And this was just before we was unloading the equipment. We was taking the equipment back to the back of the house. We was going to do the back camera first and work our way up. And, we just heard some, Linda was very agitated again, very agitated. And I just heard some light grumbling. I didn't hear the exact words and nothing like that, but again, I knew Linda was upset again. I remember. It's just.
And you said you light grumbling. Who was a light grumbling between?
You could just hear growling.
Mr. Sidley.
It was like a growler.
Mr. Sidley. You said you heard some light grumbling.
Right.
The question is, the grumbling was between Mr. Lindell Lewis and who?
And his neighbor.
All right. The person that you saw driving.
The person that I saw driving up.
And did you hear then Mr. Lindell say anything derogatory toward that person?
Oh yeah, he said it, but
I'm just asking you, did he say something derogatory?
Yes, he did.
And could you tell us what it is he said?
I mean, I can't really remember. I know it wasn't nice. He was upset. I know he wasn't nice. You know.
Was it, did he swear at her?
Yeah.
So when you would sit on the porch with Lindell, Chuck or whoever was over at that time, did you ever have any interactions with Mr. Ford at that period of time?
He would come outside on the side door and would stand there and stare at us.
Did he ever do anything, say anything?
He made some gestures, you know.
What kind of gestures?
He would hold himself.
You can say it.
Yeah, he would. He know what he do. He would hold himself.
Hold himself? Is that what you're saying?
Yes.
When you say hold himself, you mean between his legs?
Yes, sir.
All right, what did you guys do?
At first we watched him, then after a while it got so old we didn't pay him no damn attention when he come out and do that.
All right, still with us, our guest today to help us break all this down. We have former prosecutor, trial attorney Walter Gabriel. Walter, really let's focus on character evidence, and that's what this is. But my question to you is it necessarily a bad thing that you have a defendant accused of setting these fires, described as, even if it's self-described, as an angel of God or a protector of the neighborhood?
Is it bad in and of itself? No, and there are things the defense can use to bolster his character in the way of good character evidence. However, I think what the prosecution is trying to do is demonstrate that this defendant had an outsized role with relation to his neighbors in the complex. And so whenever he had a dispute with someone, it would ultimately lead to him setting this person's property or place where this person lived on fire. Because of the outsized role that he had with the neighborhood from the prosecution's standpoint. The defense is going to, I'm sure, rebut this and show him in a good light in relation to his beliefs and in his role as a protector of the neighborhood. But this, in light of a limited motive, this is what the state is going to go with to try to convince the jury that he committed these three separate acts here.
You know, there's been a real portrayal of the neighborhood, and Court TV went and saw the neighborhood, walked, and was able to say that there's a real sense of community, right? And a lot of people are talking about what happened and how tragic it was, and people are coming to court and testifying. So my question for you is, in your experience, is it surprising that we at least have not yet heard any evidence from anyone in the neighborhood that can say they know he did it, that either he told somebody he did it or they saw him do it? I mean, in a close neighborhood community, 3 fires in a short amount of time in one area, you would think perhaps somebody would really know who did this.
You would, and in the trial we just covered with Robert Durst, we have alleged confessions made in several different points. And that kind of parallels this case because you have 3 separate incidents in that case. So, you know, yes, you have a condensed area. People live very close to each other, literally. You have a person who has an outsized role in what he believes his role is in relation to his neighbors. You would think that someone he's spoken with has at some point heard him say, or at least overheard him say to someone else, yes, I did that incident during that time for XYZ reason, but the fact that we've heard none of it yet is a bit surprising.
And I will say I found in court that frequently when I was on the bench that we might hear what people think, but not what they knew, because of course human nature is often to talk about these kinds of things. I'd like to listen now with you to a little more evidence that was presented specifically about the defendant and what one of the witnesses did observe between the defendant and the victim, Lindell Lewis.
So the person that lived in that house was a young fellow that you cut his lawn, you said?
Yeah.
Did you ever have any issues with him?
No,
Did he always pay you?
Yes, sir.
Did you ever have any words with him?
No,
Did you ever see anybody else have any words with him?
No.
Lindell?
No.
Jeannie?
No.
How about the house past that house up?
That one right there?
Do you know who lived in that house?
Some boy used to stay there. He stayed at my house there for a minute too. I forget what his name was, but he done some work in that house. He done some work in that house and he ended up moving out of that house. But he stayed in the basement for a little while.
Stayed in the basement with you?
Yeah.
Did you ever cut his lawn?
No.
Did you ever have any problems with him?
No.
Did Lindell or Jeannie have any problems with him that you were aware?
No.
Did you ever see anybody else have any problems with him?
No. Yeah.
You said yeah, and?
Yeah, Stan had problems with him.
All right. Did you witness that? Did you see?
Yeah.
What did you see?
I seen him cussing him out, telling him he told me he had some work for him, you know. That's the work they be doing, putting some work. Not that kind of work, I mean fighting work, you understand.
So slang for fighting is putting some work?
Yeah.
All right, you never saw them physically fight though?
No.
You just heard the threat?
Yeah.
All right, interesting to me, Walter, he heard the threat, but the threat was between the defendant and another neighbor. It was not, in fact, a threat that the defendant made to the victim in this case. So how is that relevant to allegations of the defendant starting these fires?
Well, the connection is a bit, does require some connecting to do on the part of the prosecutors. And I imagine this was somewhat of a close call for the judge to allow this as testimony. It simply shows, from what I see, that the defendant had an argument with someone. And so that argument, threat of a fight, seems like a bit of a stretch to me that it would lead to one committing arson. That would kill a total of 9 people over 3 different incidents. So this isn't the strongest bit of evidence in a murder trial, albeit a capital trial. So we'll see what else the prosecution has to tie this defendant to these 3 arsons. But I don't think this is the strongest evidence in the world.
And sometimes I think it's important to listen to what's not heard. And so part of that, him cussing out another young neighbor who wasn't a victim, there was no testimony that he said something like, I'm so mad at you, I'm going to burn your house down. There was no threat involving any type of starting a fire. And so I think that's a missing piece of evidence. Is the state going to meet their burden? We don't know. We're going to continue to watch. But you do have to wonder on that piece. Let's talk a little bit about, they're still on the first fire. We expect them, Walter, to then move to the second fire. Now, the second fire is the one that had the total number of the family, the entire family with the 5 children, all of whom perished in the fire in their house. The emotional impact of that is significant. How, as a defense attorney, do you think they can get around the sympathy, empathy, emotional impact with the jury, or how can they at least minimize that so it doesn't hurt their client?
Well, I think one effective tactic by the defense would be to share in the empathy. I think they would be wise to express its condolences to the family, and especially those young victims of this heinous offense. It would be callous not to, in fact. But the defense here is that this defendant didn't do it. And if they are saying that he didn't do it, well, then you have no problem expressing remorse over how tragic this incident is. And lack of identity is really the strong point in this defense, because it's, as of now, something that's missing in the state's case.
And Walter, I really agree with you that I think, too, the defense has done a good job saying it's a terrible tragedy. We're not arguing that it didn't happen. It's just that our client isn't responsible for it. All right, Walter Gabriel, you're going to stay with us. The Jinx murder trial is expected to start closing arguments tomorrow in California. We're going to break that down and what to expect with Court TV legal correspondent Julia Janae up next.
I think we need a bigger yard.
With our credit?
Credit Karma can show us how to improve our credit for free. Then we can get a place with a bigger yard.
Yay! Credit Karma. Download the app today.
Helping families with mesothelioma is all we do. My firm has been offering a free book on mesothelioma for over 10 years. Since that time, hundreds of people with mesothelioma have trusted us to represent them. We have local offices throughout the U.S. and there is no risk to you. Mesothelioma really is all we do. Call us at 1-800-673-9400. That's 1-800-673-9400. Or go to mesobook.com.
Tonight on Closing Arguments, we're getting you ready for tomorrow's closing arguments in the Jinx murder trial. How long will closings last, and what should you expect to hear from each side? After such a long and unusual trial, what will end up leaving the largest impact on this jury? Plus, testimony is set to resume tomorrow in Ohio versus Stanley Ford. But tonight, we'll review everything you need to know from the prosecution's case so far.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
People have no further rebuttal, Your Honor.
Is there a rebuttal from the
No, Your Honor.
defense?
No, Your Honor.
Thank you.
You're subject to moving. We still have some exhibits to move in as well.
Yeah, so I will be considering exhibits, but the jurors don't need to be here for that. I just want to savor this moment.
Are you going to hit like a bell?
Just breathing.
That was Judge Wyndham actually savoring the moment. Both the state and the defense had rested their cases in the trial for Robert Durst. So that's it. There will be no more testimony or evidence given in the Jinx murder trial, with the defendant himself being the last witness to take the stand. But of course, the trial is not over just yet. Closing arguments are expected to start tomorrow. The prosecutor begins, and then defense attorney Dick DeGuerin will split up the defense's closing with Chesnoff. And then lastly, prosecutor John Lewin will have the final word with the rebuttal closing. Arguments are expected to last until at least Monday, with the possibility of Lewin finishing up on Tuesday. Now, since court is dark today in California, we wanted to take this opportunity to get you ready on what we can expect tomorrow for the start of closing arguments. There are many things the prosecutor can touch on, but one is something we heard John Lewin say in his opening statement, that he's going to prove more than one murder. Another major point.
The evidence in this case is going to show that he is responsible for the disappearance and the death of his missing wife, Kathy McCormick Durst. We're going to show that Robert Durst murdered his close friend and confidant, Susan Berman. And we're going to show that he did that with the motive and because she was a witness. And by witness, meaning that she assisted him in covering up the killing of his wife almost 20 years earlier. Finally, we're going to show that Robert Durst killed, dismembered, and dumped Morris Black's corpse, his body parts, in trash bags into Galveston Bay in September of 2001. So there's going to be 3 killings that we are going to prove.
Another major point the prosecution will surely bring up in their closings is the testimony of Nick Chavin, who testified to a conversation that he had with Durst at a dinner years after Susan Berman's murder.
The dinner concluded, and it was then that as we got up to leave, I realized that we hadn't discussed the 2 things that he had mentioned, Kathy and Susan. I felt kind of weird that I didn't bring it up. We walked out the door. This is hard. We walked out the door, and on the sidewalk, I said, "You wanted to talk about Susan." And Bob said, "I had to. It was her or me. I had no choice." And then he turned to walk away, and I said, "You wanted to talk about Kathy?" And he just kept walking away Nothing more was said.
And the final point that we think the prosecution will bring up is Emily Altman, who is a longtime friend of Durst. Altman testified that he told her something he's never mentioned to the authorities or the media, and that's where he was when Susan Berman was killed.
So he said he was in Los Angeles in December of 2000, correct?
Yeah.
Have you ever told that to Mr. Bagley?
Possibly, I don't remember.
At the time that he made this statement to you that he was in Los Angeles in December of 2000, were you talking about Susan Berman's murder?
He said he was in Los Angeles at the time.
Did you ask him specifically what dates in December of 2000 he was in Los Angeles? Ma'am, are you aware, as you sit here today, that Mr. Durst has never admitted to investigators or to the media that he was in Los Angeles in December of 2000? Are you aware of that?
No, I'm not.
Joining us now, Court TV legal correspondent Julia Janae. All right, Julia, let's talk about those were the points that we expect the prosecution might cover. Tell us what more you know that we can expect out of opening statements that begin tomorrow.
Well, Judge Ashley, you talked about the order of how things will go. Starting tomorrow, it will begin with the closing statement from the prosecution in this case. Prosecutor Habib Balian will start things off. He's a deputy district attorney. And then we expect that the next day will likely be the start of the defense closing statements. That's going to be separated into two parts. First with the attorney David Chesnoff going, and then Dick DeGuerin, both defense attorneys for Durst. And then that rebuttal is going to be done by prosecutor John Lewin. We understand now the reason he's going to be the one who's going last is because that's the more difficult side of the closing statements, to come last, to go after the defense, who they don't know as a prosecution team what the defense is going to say during those closing arguments. You definitely have to be a lot more nimble to talk about something or give a closing statement after you've heard what the defense has to say and be that final one. So that's what we understand as to how that has been divvied up between the prosecution team.
And Julia, you're right. You have to be nimble, but you also have to listen and really hear everything the defense has said and point out those things that you want to bring up on rebuttal. So some viewers have said, why does the state get to go last? That's because they have the burden. There's a presumption of innocence. And because the state has the burden, they get the last word in their closing arguments. Julia, when we talk about these closing arguments, we talked about it a little bit earlier, but I want to bring it up to the forefront again. And that is Judge Wyndham. We know that they had a long time for their openings. We know that they've had a very long trial. Are there any limits or expectations as to any amounts of time that he will say they have to stop after they do their closing arguments?
No strict time limits given from the judge. We do know that there have been times that he has let them know to move things along. And what the court is expecting is that Wednesday and Thursday are going to be closing statements, and then there will be off on Friday, which they have typically done during this trial. The next week on Monday, they will continue with closings, and then one more day of closings where the court is expecting things to stop at noon so that this jury can begin the deliberation. So I can imagine if things are going where they are not on par with wrapping up midday on Tuesday, that of course is Pacific time, that the judge may ask them to move things along as he has in the past.
And it's going to be really interesting. I know that we know as trial attorneys that typically you really don't object during an opening or a closing unless it's so flagrant that you really have to. So for instance, in closing, if they start to argue something that's not based on any evidence that was allowed into evidence, then of course there are grounds to object. I think I foresee that we may see objections during these closing arguments because they are all the kinds of attorneys that lodge a lot of objections. So certainly that's one thing we'll be on the lookout for. Julia, do we have any more direction from the court yet as to the deliberation by the jury, whether or not we expect them to be sequestered or rather going home just like they have throughout the duration of this trial?
I did ask that question. I know you asked me earlier today, and we didn't know for sure, but Court TV has now learned that the jury will not be sequestered. They will get to go home every day during deliberations, really the way they have been operating throughout this 54-day trial. So not a sequestered jury, but of course, when they are inside the courtroom, they will be in a jury room hammering out those deliberations.
All right, Julia, let's look now at some of the defense possible arguments and the things that we expect they might bring up during their closing arguments.
The evidence will show all of our friends talked about Susan's phobias and Susan's neuroses and Susan's fabulism, confabulism. And that's a 8-cylinder words meaning she made things up. She made her stories better. She embellished.
Sounds like argument.
The evidence will show from their witnesses that Susan told stories all the time. She told different stories to different people. Did you see your mother in the driveway?
Yes, I saw my mother on the driveway.
Relevant, Your Honor.
And Douglas Durst says that I could not have seen my mother on the roof from the window in the second floor hallway. Douglas Durst was lying. And there have been about a dozen newspaper articles, magazine articles, questioning whether I could have seen my mother on the roof.
Well, you were admitting, Mr. Durst, that the reason that you sent the cadaver note is that you wanted Susan's body recovered, correct?
Correct.
But Mr. Durst, you are disputing the idea that the first statement that you made, that it was a note that only the killer could have written, you're admitting that you said that, but you're now saying that isn't true. Is that correct?
I'm saying I made that statement because Andrew Jarecki asked me to make that statement.
I want to bring in Court TV legal correspondent Julia Janae, still with us. Now, one of the things I think the defense is going to continue to argue is he didn't do it. This is not about 3 deaths, but rather this is a trial about 1 death. Susan Berman, did he kill his best friend or not? The defense is he didn't do it. Do you expect that that might be the theme of the closing from their perspective, Julia?
Oh, certainly. They are going to hammer home that he did not do it, that he opened himself up to cross-examination, took the stand, and also denied that he was not the one who killed not only his friend and confidant Susan Berman, but his wife Kathy Durst, and his friend Morris Black, who he was involved in his death, but successfully argued that it was self-defense. I think that's actually something that's in the corner of this defense team, is that with all of these different murders that the prosecution is trying to connect together, it makes it much more difficult and murky for this jury to put all of these pieces together. So a lot cleaner for this defense to say there is simply not the evidence to show that he committed any of these murders.
And let's talk about that a little bit, because a lot of viewers have brought that up, that they think he did it, that they do believe he killed Susan Berman, but is the evidence there or not? So you and I have talked about in the past circumstantial versus direct evidence. It's rare, quite frankly, that you see a trial where there's direct evidence with an eyewitness or a video. Typically, I think those probably enter pleas, right, instead of going to trial. So a lot of them are circumstantial, and that's just putting everything together, building that house to be able to say, based on all of the totality of what we've presented, he did it. What are your thoughts about the circumstantial aspect of this case?
This one is unique in that it spans the many decades, from the 80s until now. And you have all of these people with their varying accounts of what happened, their memories. Some are strong, some are not. And there really isn't the physical evidence that you'd want to see in a case that has to do with murder. You'd want to see a murder weapon. You'd want to see DNA and forensics that attach someone. And it's really the reason that Robert Durst has been able to evade even going through the system on the deaths of his wife and of his friend, Susan Berman. It took many, many more years than we'd normally see for him to even be charged in those cases. And the one where he was charged nearly immediately, which was in the death of Morris Black, he stood in front of a jury and was able to be acquitted for that one. So in this case, you really don't have the physical, you don't have the direct, but you do have a circumstantial case worth 3 decades and many states and many witnesses who have come into this courtroom.
Absolutely, and lots of evidence for this jury to consider. Julia Janae, I always appreciate being on with you. Thank you for your time today. Opening statements are set to begin tomorrow in California for the trial of a fallen health tech CEO, Elizabeth Holmes. When we return, we are going to take a look at what we can expect in the trial with Court TV's crime and justice reporter, Matt Johnson.
In all the years that I've covered trials across this country, this one is the most divisive.
Kyle Rittenhouse awaiting trial.
Chaos erupted in Kenosha overnight.
Who shot 3 people in Kenosha, Wisconsin during the riots. 2 of them died.
Rittenhouse has pled not guilty to murder and all charges stemming from the incident.
Kyle Rittenhouse thinks he's above the law. He was an active shooter and he tried to flee.
He's the one who went down armed with an assault rifle, armed with a rifle that was almost half the size of his body, which is crazy.
The issue really will become, was he justified in using lethal force in defending himself?
Who struck my client first? Who attacked my client first?
I've never seen anything like it before here on Court TV, ever.
Good Tuesday afternoon. Welcome back to Court TV Live. I'm Ashley Wilcott, honored to be with you. Opening statements begin tomorrow in the federal case against the fallen tech star Elizabeth Holmes. She is facing a dozen felony charges alleging that she knowingly misled investors, patients, and doctors with falsified claims about her company's blood testing technology. So happy to bring in Court TV's crime and justice reporter, Matt Johnson, who has more on what we can expect in the upcoming trial. Matt, tell us all about it.
Well, Ashley, pleasure to be here with you. This case has all the makings of a Hollywood movie, a Hollywood drama, a love story gone wrong, a failed startup, and famous investors. Tomorrow, opening arguments are set to begin in the trial against fallen tech star Elizabeth Holmes. 2 years ago, Holmes and her ex-boyfriend, who was also Theranos COO at the time, Ramesh Sunny Balwani, were indicted by a grand jury on the dozen felonies. Prosecutors allege that they knowingly defrauded high-profile investors with false claims over blood testing technology. Holmes promised that that technology could run hundreds of medical tests using a single drop of blood. Now, for her defense, Holmes' attorneys say that she did nothing wrong. She was the victim in this case, victim of fake-it-till-you-make-it culture out in Silicon Valley, California, a victim of an abusive relationship with then-boyfriend Ramesh Sunny Balwani, who was the company's COO again. Court documents claim that he controlled all aspects of her life and her decision-making, and that, quote, he dominated her. Ashley?
An interesting part of her defense. Certainly, I know you're going to keep us updated on what they argue as they move forward. A reminder to all viewers that this is a federal case, so it will not be televised. We will not be able to record or show the actual trial, but we will bring you the details because this is one, Matt, that has a lot of attention on it. So tell us first, let's start at the beginning, the jury pool. I understand there were more than 200 people in the potential pool. Fast forward, what is the jury makeup at this time?
Right, that's a good point, because here's a snapshot of that jury makeup. Remember, it started out with 200 people and then whittled down. The jury is made up of 12 jurors, 5 alternates with 7 men and 5 women. They're diverse in age and ethnicity. Now, they were also given a questionnaire, at least 28 pages, Ashley.
And that's not unusual. I stuttered because especially federal court, right? So questionnaires can be very long. They ask a lot of questions because they really need to delve in to determine which of those jurors can serve without being biased or have any preconceived ideas about the case. And that leads directly to the next question I have for you, Matt, and that is the high-profile nature of the case. How did they deal with that in the jury questionnaire?
Right, it's hard to escape. I mean, we were talking about it when we were getting ready for the newscast today, right? So the podcast, the documentaries, the news coverage, and especially right there in the Silicon Valley in Northern California. One juror was actually dismissed because she said that she watched a documentary about Holmes and she felt bad for her because she wanted her to succeed as a female CEO, Ashley.
So this has been a really interesting case, and you and I did talk earlier, and you had some great materials that I was reading through because I'm just one of those trial nerds and like to do that. But I found very interesting, Matt, that one of the things was her voice, and she has a very deep voice that she's known for, and there was some argument that, oh, she didn't always have a deep voice, she's made it that way, and then there's family that says, oh no, she's always spoken that way. The deep voice makes me think of another question that I have to ask.
Right.
Will the defendant take the stand? Is there any indication that she is going to take the stand and be heard speaking on her own behalf?
Right, and what voice will she use? The one that she claims is authentic, or the ones that former Theranos employees say in a documentary that it was made up? Well, yes, Holmes and Baldwani are basically blaming each other. She is expected to take the stand in her own defense, and she basically wants to paint the picture that she was a victim, and also talk about the recent court documents that were released where she paints a picture of being a victim to Baldwani.
Yeah, that is something that there are a lot of defenses being raised in this case. And I know, Matt, again, in preparing and reading through it, you're more familiar with them probably than I am. But a couple of those defenses include, I mean, one of the big issues is knowingly. Was this intentional? Did she intentionally defraud these providers? And so tell us, is there anything else about intent you can share with us? Because I think that's going to be the crux of the case for the prosecution.
Okay, she says that basically her defense is going to rest on the fact that she didn't do anything different than what any other Silicon Valley CEO would have done, inflated the truth, or, just believed in their product. So that's her defense. However, prosecutors say that this case rests in intent. She intently knew what she was doing, and she, quite frankly, broke the law after selling what she was talking about after she knew it didn't work. Ashley?
All right. Thank you, Matt. So great to have you on. Thank you for all your updates on this case as we prepare for that trial to get started. We are going to take a look at what to expect tomorrow in the arson death penalty trial, as well as the Jinx murder trial. Up next here on Court TV Live.
It's just so hard to know where the truth ends and then fiction begins.
New developments in the case of doomsday cult mom Lori Vallow and her husband Chad Daybell.
Authorities are still searching for Vallow's children.
How does she pose a threat to your children?
I don't know what she's going to do with them.
Think about all the people that had to die and disappear.
Tell us where the kids are.
Nothing is coincidental.
This stretch is just so beyond what anyone could imagine.
Investigators have recovered human remains at Chad Daybell's residence.
There's no way, Logan, I could ever come up with this.
This is no longer the search for missing children. This is the search for killers.
All eyes on this Idaho trial.
Lori was his follower. Chad Daybell's the prophet.
Chad had a vision, plagues and foreign troops coming to the soil.
It's the doomsday couple, Chad and Lori Daybell, on trial.
Live Court will resume tomorrow on Court TV, so let's take stock in where we are. First, in Ohio, the testimony is expected to shift from the house fire in April of 2016, which killed Lindell Lewis and Gloria Jean Hart, to the house fire killing Dennis Huggins, Angela Boggs, and their 5 children. Shifting gears to California, after 54 days of trial, we are finally expecting closing arguments in the trial of Robert Durst. I want to take a look back at some of Durst's testimony and moments where Bob said he misspoke.
You would agree, Mr. Durst, there have been a lot of times in this trial when you say something, I then put up a clip that says something directly different out of your own mouth, and your response has been, I misspoke, correct?
No.
Sustained. Stricken.
Who was it that directed you to say hi to Mommy while she was outside on the roof?
My mother's father, my maternal grandfather.
Can you explain why you told Andrew Jarecki that it was your father?
I misspoke. Whether we were playing Go Fish or Uno or Frisbee or whatever, it was always Mommy and Bobby against Daddy and Douglas.
the Frisbee was not invented until 1957, and that the game Uno was not invented until 1971. Can you explain why it was that you testified to what you've now said was a vivid memory involved?
I misspoke. I think I misspoke when I said I get a big kick out of beating the government.
What did you mean when you say you misspoke? What did you intend to say?
I think I was going along with one of Andrew's hints. I wouldn't like to live in the same building as Susan Berman.
Mr. Durst, didn't you just say that, no, my point was I wouldn't want to live in the same apartment, but I'm happy living in the same building? That's what you just testified to, correct?
Correct.
That's not what you said 4 days ago, correct?
I misspoke.
Mr. Durst, you have testified, depending on your version, that he tripped from the leg of the table or that he tripped on the chair leg. You agree those are not the same thing, correct?
I misspoke when I said leg from the table.
You would agree you either lying under oath in Galveston when you said 6:15 or lying under oath on August 16th when you said it was 8 or 9, correct? They can't both be true.
When I said 8 or 9, I misspoke.
And it's your position, Mr. Durst, that your misspeaking was just a issue with your memory recollection, is that correct?
Correct.
You could not have bought a bow saw at Chalmers after Morris Black's death, correct?
Correct.
I want to play another clip for you, Mr. Durst.
I mean, the whole thing is contradictory. The whole 3 paragraphs I said to Andrew are contradictory.
Right, an alternative explanation would be, Mr. Durst, that you cannot keep your lies straight and that you are telling partial truths about having bought a saw at Chalmers.
An alternative is that I misspoke. I was confused when I spoke to him.
You talking about the fact that Kathy was buried would seem, Mr. Durst, you would agree, to be implying that you know, in fact, that she was buried, correct?
So when I said buried, I misspoke.
Well, when you say you misspoke, Mr. Durst, was I talking about where Kathy was buried?
You were talking about a hypothetical if she was dead.
Did I mention her being buried at all?
No.
Who's the only person that mentioned her being buried?
Me.
Oh, you know what? There is a typo in my, thank you. So, among the big lies that you've told was about not having traveled to Los Angeles in December of...
You misspoke.
No, it's a typo in my outline. And then I misspoke both.
Very clear. The record is correct.
Yeah, no, that's not what I meant.
It's John's mistake.
Yeah, my mistake. Absolutely. Twice. Writing it down and then speaking about it.
All right, with us to help break this down, former Assistant District Attorney, Trial Attorney Walter Gabriel. Walter, so many different things going through my head. Let's start with this one. How hard do you think it is for a jury, after sitting this many months, listening to this huge amount of evidence, to now listen to closing arguments for what could be up to 3 days?
Well, I think it's going to be a treat for the jury, honestly. This prosecutor was so into the minutia of these different things that he categorized as lies, which a reasonable person could categorize them as misspeaking. And so when we get into closing, it'll be just the keynotes from these 50 plus days. And I'm looking forward to seeing in this closing on the defense side how they choose to embrace the lies. As Robert Durst admitted on the stand that he committed perjury 5 times. They're going to have to address in some sort of way why he repeatedly said one thing and then said another on these different issues. And I think what's going to make this topic so key is the statement that he apparently made to, I think it was Nick Chauvin, about the murder of Susie Berman. So they're going to go through the standard in the defense close on, how different burdens weren't met in different areas by the prosecution. but these lies are going to be embraced and somehow repackaged in a way that favors the defense. They've said at different points that he was possibly high on drugs during an interview. They said that Susie Berman liked to tell lies that were fabulous in nature. It'll be very interesting to see what the defense does with this lying element that the state is predictably going to make a major element in its initial close.
And do you think it's important when you have opening statements by both the defense and the prosecution, do you think it's important in closing to go back and reiterate what the evidence did or didn't show? And let me give you a specific example, because the opening statement, and you can see them there when they made their opening statements, of John Lewin said that there was going to be proof that all three individuals were killed. Well, arguably, there's no proof that the wife of Durst was killed. Rather, she disappeared. And so are those inconsistencies you think they should explain, or do you think you can kind of gloss over those to focus instead on things like the lying that Durst did while he was on the stand?
I think when it comes to opening statements, I think juries more often hold prosecutors more accountable in their opening statements to the promises that they make, because they're the one that has the burden. They have all the evidence that they've gathered and chosen to indict on their own timing. I think the defense is given more leeway because the defense, in the jurors' minds, doesn't quite know what's going to be brought against their client, and they're in defense mode throughout the trial. So I think more leeway is given to the defense than prosecution, and I think that's going to be something that the prosecution is going to have to own up to not proving, or try to convince the jury that they did in fact prove that 3 murders were committed by this defendant.
Right. So let's take us to the next step, and that is, as we heard from Julia Janae earlier today, she did confirm the jury is not going to be sequestered while they're deliberating. Now, given the amount of evidence that they have to make a determination of fact and then apply the law to the fact, I don't anticipate it will be only 1 day of deliberations. I just can't imagine that's what will happen. That's just my opinion. So overnight, they'll still, just like trial, be going back home. Do you think in a case of this magnitude that makes any difference or potential for any outside information when they actually go home for the day?
I think it was wise for this judge to keep the jury, to treat them consistently as they've been treated throughout the trial. There have been no reported instances that I'm aware of where a juror has self-reported or someone else has reported outside influence to a juror, or any statements made on social media anywhere else that indicates that they've had some sort of outside influence.
Right.
And as you said, the deliberations are going to last for quite some time, because jurors often ask for exhibits. They often ask for different questions. And in a case like this, they're likely to come back to the court with several questions as they're deliberating.
Yep. Sorry to cut you off, but we're out of time. Thank you so much, Walter Gabriel, for being with us today. That's it for me. But up next, Joy Lim Nakrin is in the anchor seat for Michael Ayala, who will be here later on Closing Arguments. Don't go anywhere. Stay tuned here for continuing live trial coverage on Court TV, your front row seat to justice.